Is Mr. Young the final witness for the
Yeah, we'll bet.
appeal? Okay. We've heard from both sets of, we've heard from both sides for opening statements. Both sides have called their witnesses. We're now ready for closing statements. As we do in other steps of this process, the department will go first. So up to Attorney Headley for the closing statement on behalf of the Office of the City Attorney.
Thank you, President Bach, and thank you, commissioners, for your time and attention. I recognize that this has been 4 days from you, and we appreciate from the Office of City Attorney your time, attention, and dedication to the city as a whole. I will harken back to my opening statement last month and indicate again that the city attorney's position is that Mr. Young was simply not qualified for the position. I would direct the commission's attention to look to the various exhibits that were submitted by both the appellant and the department, specifically Mr. Young's job descriptions, both of them, which are nearly identical in form and in function and in what he was expected to do from the time of his employment beginning in January 2022 until he was ultimately separated in December rather of 2024. And the reason for this is, as I think has been made abundantly clear, is the job position requires access to CJIS information and requires the ability to have CJIS clearance to access the machines themselves that house the important data that is governed by the CJIS policy. I want to make this abundantly clear because we have used many terms throughout this. CJIS is a policy. It's evident in the document D12 before this commission. It is a contract that the federal government enters into with the municipal governments for the government itself to access sensitive criminal data information. That access is central to and paramount to the safety of the city, because without it, our officers cannot access information as to whether a suspect has a warrant, has an active criminal case ongoing, and would essentially be forcing the department to use 1800s mentality and technology rather than the technology of the 21st century. It's also essential for the Office of the City Attorney to be able to utilize and access CJIS protected data. Again, we are talking criminal information from the various individuals who appear as defendants in the municipal court. We are talking about traffic data that is accessed again by the assistant city attorneys who prosecute municipal citations and various issues regarding municipal law in front of the municipal court system. Again, without it, the Office of the City Attorney could not function in municipal court. You heard testimony from the city attorney as to the essential nature of this information and how without it, the municipal court would grind to a halt. Because we have access to this data and because our jobs require the access to this data, folks who work on the machines, on the computers, need to have specialized clearance, need to have the CJIS clearance. Even more fundamentally, in order to even access the office of the city attorney's building or section in the police administration building, every individual must have CJIS clearance to have unescorted, unencumbered access to the facility itself. Those two things are not changeable. Those two things are facts, and those facts cannot be ignored. In order for our staff, in order for the Office of City Attorney staff at the Ordinance Enforcement Division to have access to both the building and to access to the criminal justice information, they need to be sponsored by the Milwaukee Police Department. Milwaukee Police Department has to indicate, as in J1, has to sponsor the employees to have unescorted access into the facility and to have access to the information. What again is abundantly clear and is a fact that Mr. Young agreed to himself is that he did not pass that provision in 2022. He did not pass it in 2023, did not pass it in 2024, based upon his conviction history, which again is in our record, which he also indicated has not changed, neither additions or subtractions to, since 2022. You also heard, again, a fact that is clear, is that CJIS has a tri-annual audit policy. The last one you heard testimony for was in 2021, which predates Mr. Young's employment with the Office of the City Attorney, and he again agreed to that. The first time that the Office of the City Attorney had an audit for CJIS during Mr. Young's employment was in November of 2024, as evidenced by D2. In that audit, you heard testimony from the city attorney. There was questions as to who was cleared to access these forms, access this information. Specifically, the department was asked, does the agency's background check include submissions of fingerprints to CIB and FBI for all personnel with access to the agency's physically secure location? The answer there was either a yes or a no. The audit also indicates that applicants with a record of misdemeanor offenses may be granted access if the CSO or his or her designee determines that the nature or the severity of the misdemeanor offenses do not warrant disqualification. In 2024, Mr. Young did not pass a background check. There is no way for the Office of the City Attorney to be able to accurately, completely, and consistently answer these questions in the affirmative. What you have then is an individual who does not have CJIS clearance, who potentially is violating the CJIS policy and accessing the facility, the physical building itself, and also accessing the machines to work on OED staff's technology issues. When management in 2024 received this information, received this audit and reviewed it, they realized, Ms. Channing testified, that there was an issue. There's one of two options. One, lie to the federal government, or two, put Mr. Young on administrative leave to determine if there's something that could be done to maintain his employment and to not have to lie to the federal government. So that's what the Office of the City Attorney did. In November 20th, 2024, Mr. Young was placed on administrative leave. Ms. Channing reviewed the documents that were in her possession, including Mr. Young's background check, the 2022 denial of access. She reviewed with AC Sarno, with Assistant Chief Sarno, that an individual with certain convictions would not be sponsored by the department. Mr. Assistant Chief Sarno answered in the affirmative. And to be clear, Ms. Channing did not supply Mr. Young's criminal conviction history to AC Sarno at that point in time. She was asking clarifying questions to ensure that her understanding of what occurred in 2022 would occur again in 2024. That was answered again by Assistant Chief Sarno per his testimony in the affirmative. When he later reviewed the specifics of the criminal conviction history, he indicated, yeah, no way would I sponsor, no way would the department sponsor this individual to have access to our facility, let alone sensitive criminal database information. Ms. Channing met with DER for guidance. Ms. Channing requested some information, tried to figure out what best she could do to help with that. Ms. Channing confirmed with MPD. Ms. Shanning reviewed the background check. Ms. Shanning reviewed the rules of the CSC. Ms. Shanning reviewed the Wisconsin Fair Employment Act. Ms. Shanning reviewed case law in possession by the city, which indicates that denying somebody access to the building and denying employment because they couldn't get access to the building was not discriminatory on the basis of conviction record. Ms. Shanning reviewed the CJIS audit questions. Ms. Shanning reviewed the job description and determined that there are certain functions and features of the job without CJIS clearance that could not be performed. Mr. Young was presented with these. This is all part of her due diligence, to be clear. Ms. Shanning testified to everything that she did to ensure that Mr. Young could not get this CJIS clearance, including the possibility of expungement, which, as you heard from Mr. Young himself, is an impossibility, as well as for Mr. Goyke. Armed with that information, the only reasonable decision that the department could come to was that they needed to separate Mr. Young from employment to be in compliance with the federal policy to access essential information and to ensure that we are in compliance, the city is in compliance with the CJIS audit. Any other outcome here is not only unreasonable, but it is ridiculous. Armed with that information, the city attorney had the only option that he could do was to separate Antoine from employment. That was not a decision that Mr. Goyke took lightly, that the city attorney took lightly. You heard from him directly. He had no issue with Antoine. Moreover, he liked him. You heard previous city attorney did not give Mr. Young an office, even when he asked. The current city attorney not only gave him an office, let him choose it. Current city attorney had no issue with him coming back and even indicated to him, if you could pass CJIS clearance, we'd be in a different spot. We wouldn't be here. Told it to him. Said to you that today. I understand that it's been a long time since you heard the city attorney speak, and then you heard the facts that Ms. Shanning presented. Based upon your very detailed notes and based upon the evidence that is presented in the documents that are submitted to you here today, and again, to be clear, the appellants and the department's own exhibits plainly indicate that there would be no other reasonable outcome or reasonable choice to make but to separate Mr. Young from employment. And that's the standard that you must employ as per the CSC rules, as I know you know, but I want to reiterate that the decision here to separate Mr. Young from employment was not only reasonable, it was the only one they could make based upon the facts that exist, that are unmutable and unmovable. Thank you so much for your time and appreciate it.
Finally, we go to the attorney on behalf of the appellant, Mr. Young,
All right.
for his closing remarks.
Thank you very much. And thank you for your time over all these days here to hear this appeal. I'm going to focus on the elements of a Wisconsin Fair Employment Act claim for conviction discrimination here in much of my remarks. While I understand that you have your own standard here, I think that it's important for us to understand essentially what the law is on conviction discrimination here, because essentially it's the claim that, from my colleague, that this is outside of discrimination for conviction. So when we look at those kind of claims, the first thing we do is try to determine whether or not we have a prima facie case here. And that simply means, well, what we have. Mr. Young has been convicted of misdemeanors. We don't dispute that. Mr. Young has been terminated from his employment. That's an adverse employment action. I don't think anybody disputes that here. Or may potentially be separated, I guess is another way to put it. Now the question is ultimately whether or not the conviction record is motivating factor in the termination. I don't think there's any question that it is. There's no doubt that but for Mr. Young's conviction record, that he would still be employed by the city attorney's office. And we can trust the city attorney when he says that. We can trust the documents in this case when they say, but there's no disciplinary issue whatsoever. The only issue is Mr. Young's conviction record. So then we have to go to whether or not there's a legitimate business reason for this action here, which is what this case is ultimately, this hearing has ultimately been about, which is the city attorney's attempt to say that they have a legitimate business reason here. Now, we have had testimony that I think clearly shows that the reason that the city attorney is giving is pretext. Meaning, and to be clear, we need to say this out loud, that the city attorney, instead of discriminating, being obvious with his discrimination, is using this as an end run to remove Mr. Young. We heard from the city attorney's own mouth that he was going to place Mr. Young on a PIP. We also heard from the city attorney's own mouth that the removal or the decision not to place Mr. Young on a PIP had nothing to do with this action or anything, he just did it. Because why? Because the CJIS audit told them that they had this existential black and white decision that they had to make, and that, by golly, took precedence over the PIP. That is if we're to believe the city attorney. Now, the problem is that Sharon Crow came in and testified that the city attorney told her to remove or to discontinue the city attorney's plan for a PIP. Why? Because of the complaint against by Mr. Young against Ms. Sanders. And we heard confirmation from that today that the city attorney and Ms. Sanders decided that the optics weren't good. The optics weren't good. So they then took steps, the city attorney and Ms. Sanders, to remove Ms. Sanders ostensibly from these management meetings here. Well, why would they need to do that if that wasn't on the city attorney's mind? And it is significant that a sworn attorney, says one thing about his reasons, and that an independent third party, Ms. Crow, says something completely differently. And it's important to note that Ms. Crow made a lot of statements that were in favor, supported the story of the city attorney many times. But when she differed, boy, did it matter. Because we were told time and time again here that the PIP had nothing to do with anything. That the decision by the city attorney and the complaint by Mr. Young had nothing to do with this decision. That the only thing at issue was the failure, we'll say, the alleged failure, to be accurate, of Mr. Young to be certified for CGIF. Next, we just look at the process. Now, to be clear, many outside bodies are going to be suspicious of this decision here because of what happened under Mr. Spencer. And now we didn't bring in Mr. Spencer and he was willing to testify because we were very clear and understood that you didn't want to go there. So we didn't go there. But it nevertheless, the evidence on that issue make it, I think, abundantly clear that it was not handled. The original termination of Mr. Young was improper. and frankly illegal. The evidence before you indicates that the then city attorney was not made aware of the decision. And just sitting here today, how many of you commissioners have ever heard of a time when a deputy makes the decision for the city attorney to terminate somebody without notifying the city attorney themselves? I submit to you that's never happened before. Now, there's probably a good reason for such a divergence of the normal policy. And there's another divergence of the normal policy, because if you look on the form, it says that that information is to go to the city attorney. But for some reason, it went to Robin Pedersen. We've also heard testimony from two other deputy city attorneys, Ms. Shanning and again, Ms. Sanders, that somebody out of the blue contacted them at some time, they don't know when, and discussed Mr. Antoine Young's employment conviction record. Now, when witnesses say that they don't, especially two witnesses say out of the blue that they have no idea of the facts of when they were told, who told them, or why, or the actual discussion, we kind of think that they're not telling the truth. Those are indications of lack of credibility here. And again, it's not only just one, it's both of them. And both of them couldn't remember the exact same fact. What they could remember, that they were told that Mr. Young had a conviction record, but that's it. And to be honest, that's simply not credible and not the best look here for, again, licensed attorneys. Mr. Pedersen also testified that he was aware and discussed Mr. Young's conviction record. An outside body is probably going to think, hey, these people in their discussions, they have a PIP. That's their plan. The PIP plan kind of got squashed in the bud because Ms. Sanders came in and started swearing and couldn't control her mouth. Okay, these things happen. So they moved on to plan 2, which was it's not possible for him to be employed here. Then they don't have to worry about giving a reason. They don't have to worry about just cause. They don't have to worry about any of that. We can just move on to he is not qualified. Now, what's the problem with that? Well, let's just look at the timeline here a little bit. Mr. Goyke testified that he doesn't know the policy. He doesn't understand the policy. We had questions of Mr. Young. He doesn't understand the policy either, but that's okay. He's not the city attorney. But you know what the city attorney didn't do when he didn't understand? If I don't understand a law, I go and consult sources who do understand the law. That's what I do, because I want to know. And the first person might not tell you the right answer. The second person might not tell you, but you go consult sources until you find out. Now, what did Mr. Goyke testify that he did to interpret the policy? He relied on his own interpretation. Did he go consult the experts? He told us he did not. That was his decision. He could have contacted the FBI. He told us he chose not to. So that's another thing that's going to make outside bodies wonder, hey, is he choosing not to because he's made a predetermination to remove Mr. Young because he doesn't like people with a criminal background, for some other reason? And when we talk about the totality of the circumstances, and you think about the fact that Ms. Crow contradicts the city attorney, it's troubling. And then we go and we examine the sort of second attempt in 2024 to examine Mr. Young's background. Now, we spent a lot of time on this on the first day, and I kept saying, are you the criminal justice information officer? Nobody knew that. I supervised the criminal justice information officer. Okay, but are you that person? Is there some document anywhere that shows that you have the authority to make this determination? Well, no, I supervised, the person that has the authority to make that determination. Okay, but we've heard from my colleague here that this is a contract. It's a legally binding agreement. And so you can't have it both ways. It can't be loosey-goosey for the city attorney's office, but stringent when it comes to the convicted man. Who, by the way, the city, how many times have we heard the city of Milwaukee pride itself on giving people second chances? Because that is what this case is all about, is giving Mr. Young a second chance. We thought that that had happened, that Mr. Young had been given the job to do, that he had performed it successfully. But no, he's on eggshells the whole time because there's a group in the city attorney's office who want to go behind his back, talk about his criminal record, let everybody else know about his criminal record, which they shouldn't have had in the first place. Make it everybody's knowledge. He's got to be the butt of jokes. Don't steal anything, Mr. Young. Don't steal anything. An employee hired by the city of Milwaukee and entrusted to be in that position. He passed the background check. And yet it's allowed to continue. And then I continue to submit to you is what this is all about. These grown adults cannot face the fact that what they are here to do is remove a man and to refuse to give him a second chance. And if they want to get, why are they going behind his back and sending out text messages to people who aren't even employed at the city attorney's office to talk about Mr. Young's business? Why are they doing that? And is an independent body going to say, hey, doesn't that these same people who are going behind his back, who can't remember, who are, let's also recall the testimony of Mary Shanning. What did she say? She was soliciting complaints. She was asking people to write them down, to give them to her. What did we hear from Mr. Young? She never presented any of those complaints to him. If we were going back and talking about progressive discipline, which, you know, they've short circuit here, you would assume that the first step in progressive discipline is to allow the man to have an opportunity to change. And instead of doing that, what did we have? A perfect opportunity came up that we don't have to allow him to change. We don't have to give him any response whatsoever because it's a done deal. Which I think brings us to some of the most important contradictions in their position. We learned, because it's in the document, and my colleague reminded us, that the decision of whether or not to grant CGIS clearance to Mr. Young resides with the city of Milwaukee. And that's fact. It's in the contract. ACR Sarno could give him authority tomorrow. Period, the end. He could. Sorry, did I hear something from my colleague? Because that would have been inappropriate. So he could. That's what the contract states. That the CGIS officer has the ability to waive when there's a felony. No. It's no. If it's a misdemeanor, it's a determination to be made by the city attorney's office. Now, if this was a fair process, something that you might think could have happened was that Mr. Young could have been allowed to resubmit or to submit for the first time a new clear application. But that's not what happened. Nobody went to him and said, hey, fill out this form again. Let's see if you can pass it. I don't know. They didn't. What the testimony was is that Miss Mary Shannon greased the wheels. She went to ACA Sarno and said, hey, I've got somebody, I won't tell you who it is. I'm not going to give you any facts about them, but if it's similar to this situation, then what would you do? And we also, when did we learn that that had happened? After the separation of Mr. Young from the city attorney's office. That's why when they came up here and made their opening statements, they have not proved what they came out to show. Because their whole argument ultimately goes down, and we heard Mr. Goyke address this and others. They told you that the sky was falling down. They had to act. There was no alternative. Well, we know that that's just not true for several reasons. We know it's not true. Because if it had to be the case, this is what, remember his own words, we couldn't tell the federal government, we couldn't lie to the federal government. And, you know, I'm not for lying to the federal government. But that was a false dichotomy. The choice that they presented before you was not accurate. It was untrue. Again, my client was never given the chance to reapply. It was Mary Shanning's suggestions and greasing the wheels and telling the ACA her side of the story and what she wanted. Let's not forget another thing that the ACA told us, that they told him, was to prepare your testimony for hearing. You recall that? That's not a fair conversation with Mr. Young. That's not a fair opportunity for Mr. Young to represent himself before the actual decision maker, which again wasn't Mr. Sarno because he's not the CGIS. So that never happened. And when it supposedly did, because that's what they told you was, they told you at opening arguments that before they made the decision, they had an existential black and white crisis. They couldn't lie to the FBI. And it turns out that they never actually established until well after they made the decision, what they, with the person, with ACA Sarno, because that's Ms. Shanning's testimony here. Again, I think that the hard breathing is completely inappropriate. And that, again, I submit, is why the argument or the business reason stated by the city attorney is mere pretext. And I'm explaining to you here that I think an independent body, like, for example, the Wisconsin Equal Rights Division, will have the opportunity to analyze this case under that rubric here. Because part of what the test is there is whether or not their proffered reason is accurate. We've gone through all the inaccuracies. The final question ultimately is, were they motivated by his conviction record? I think they clearly state that. They clearly state that. But again, the text messages, the communications appearing out of nowhere for Ms. Shanning and Ms. Sanders, who were not, while they were not even employed at the city attorney's office by someone, and you know, if they could remember who it was, it certainly would be a big problem for the person that told them, wouldn't it? Because that person would probably be coming under some disciplinary sanctions for having divulged Mr. Young's criminal record to the people who then become the decision makers. And so that ultimately is part of the problem that they cannot conceal here, is that all of the people who were involved in making this decision were aware illegally, frankly, illegally, of Mr. Young's conviction record. And that is going to be a factor that's going to weigh heavily against the city on should this issue arise, as to whether or not his decision was in fact motivated by animus against Mr. Young and his conviction record. Because we can certainly see it, from my perspective at any rate, Ms. Shanning seems to be overly concerned about Mr. Young's conviction record. Mr. Peterson seems to be overly concerned about Mr. Young's conviction record. Ms. Sanders seems to be overly concerned about Mr. Young's conviction record. And frankly, so does the city attorney. And what is that all based? All of that concern on the one hand is balanced on the fact that they are not able to present any facts to you that suggest that Mr. Young was not able to do his job. And in fact, what we learned, because they didn't tell us, we had to find this out, and presented to you was that the person who is now doing Mr. Young's job, remember, it's an existential black and white crisis. We can't lie to the FBI, but right now, today, which completely undermines their case more than any other fact, is that the person who is employed doing Mr. Young's job is a temporary worker who is not CGI certified.
Objection misstates the testimony of the witness.
And that fact, again, beyond all else, is what we submit to you undermines the city attorney's position. We had, I believe, the head of the municipal court of IT for municipal court. He's the one who told us about the temporary person in that position. He's the one who told us about her lack of clearance. We also have testimony from the city attorney that he knew of no issues with CGIS security, but yet told you that Mr. Young's conviction record was of such a magnitude that there was no alternative. You have no alternative. You've heard him say that. You've heard him argue it. Well, they're trying to argue you into, and to the city, frankly, into discrimination against Mr. Young based on his conviction record. And I think we all know in our hearts, because this is the easiest test of all, is the but-for test. And but for Mr. Young's conviction record, he would still be there today. And I think that is, when you take the fact, again, that the city of Milwaukee is in charge of and makes the determination over whether he could be CGIS clear because he's not a felon. When you take into account Mary Shanning's communications with that person, them preventing Mr. Young from filing a new application on his own, and then telling us and documenting in the world that it was not possible for him to be hired on November 27th. And you can all listen to the testimony of ACA Sarno, that he didn't talk to Ms. Shanning until December for them to be able to back up these facts that they said. And let's not remember that Ms. Shanning was so clear that she needed her facts to be backed up that she told ACA Sarno, get ready for a hearing. Normal people don't do that. Normal situations, you don't tell somebody, hey, after I fired somebody, we need you to be prepared to go tell our side of the story. You don't tell people to tell the truth. They just tell the truth. So we, again, submit to you that this isn't just cause. This isn't anything like it. And it certainly doesn't meet what your standard is here. Because ultimately, what's at issue is whether or not the city of Milwaukee should be giving people like Mr. Young a second chance. And we look at DPW, we look at all over this employment of the city of Milwaukee. The city of Milwaukee takes pride. And the people of the city of Milwaukee take pride in the fact that the city hires people who have had problems and gives them second chances where other people might not. And frankly, Mr. Young went from being in a position of really relatively low hope to now being in a position where he has had a career. He's got years of service at the city of Milwaukee all behind him because the city of Milwaukee gave him a second chance. We've heard testimony finally that he passed a background test and did whatever additional above and beyond for the city attorney's office. And that everybody knew what his situation was. So again, we submit that beyond being just cause, we think that this is discrimination under the Fair Employment Act because the reason the owned contract itself gives the authority for making Mr. Young CGIS clear certified to the city of Milwaukee. So for the city of Milwaukee to say that we have no choice when the city of Milwaukee has the choice of pursuant to the contract, that's what the problem is here. And again, hey, The city attorney didn't understand the contract very well. He testified to that. It's okay. But what he didn't do was go and find somebody else who did and consult the FBI or maybe somebody else. What they did do was consult the Wisconsin Fair Employment Act to say, hey, we can tell you all, we can tell Harper Donahue that this isn't discriminatory. When Harper Donahue pushed back, then they went and read the Wisconsin Fair Employment Act. Just another red flag to you all that what they're concerned is making it appear not doing what they're doing, which is engaging in employment discrimination on the basis of conviction record here. And Mr. Young should have his job back because the city of Milwaukee gives people second chances. It gave Mr. Young a second chance. And what's happening here is people in the city attorney's office do not want Mr. Young to have a second chance, but that is what this commission stands here for, is to be a check and a balance on that. What did Harper Donahue say? Go do your due diligence. Well, we submit that the due diligence was self-serving because they were animated by employment discrimination from the beginning, which is a shame. The people of the city of Milwaukee deserve better, and frankly, so does Mr. Young. Thanks again for your time.
Commissioners, we have the option of going into closed session to consider this matter. Is there a motion to that effect, or you want to do it in open session?
I can make the motion. I can make the motion. I move that for the commission to convene in closed session as authorized by section 19.85, paren 1, paren A, Wisconsin statutes to deliberate on the separation appeal of Antoine Young.
I second.
It's been moved and seconded to go into closed session regarding this matter. I'll poll the commissioners. Commissioner Miller,
Yes.
Commissioner Smith,
Yes.
Commissioner Clary.
Yes.
We're in closed session.
That's what
I'll text.
I keep getting phone calls from her that says no caller ID and I can't call back. But
Oh, you wanted,
I've got 12 numbers for her and I still get.
the city lines do that.
Oh.
When you call out. it-
Mhm.
Okay,
Tell you-
President Bach, please be on standby for just a moment.
Yes, we're here.
Received a message from her saying that today's meeting was starting. at 9.
Kristen, are the mics on?
She
That
said
white
just-
button I showed you?
The mics are on.
Okay.
the memo
You must have
about
turned them
Joe
back
Allen.
on then, right?
That's where.
Yes, ma'am.
Thank you. Okay. We can unlock that door, Kristen, and let them back in.
Okay, and I'll announce, we are back in open session.
Said July.
Yes.
Said it needs to start.
Yes, it did.
So
I was glad.
so I was a little rattled.
Yeah. it was-
Wait a minute.
She had just texted me because I. texted her,
Maybe
yeah, and she sent me up on here, it's
Yeah.
1 o'clock. so
Yeah, that
I
helped.
know She didn't really want July date.
No, she does, but as a part of that, it said that today's meeting started at 9. And I wasn't ready for that.
Yeah,
So I got back to her.
getting all kind of messages from our other things. It'll say cancel, then that confuses everybody, and then everybody's calling me, oh, is the meeting canceled? No, it's not canceled. We were meeting.
Marilyn, who is it that you are so
It's
into?
confusing, because we normally meet by Zoom, but we were meeting in person, so we were canceling the Zoom, not the in person. Everybody confused.
About what?
One of our meetings. that we
Oh.
had.
Yeah, I have a bunch of, seeing things coming flying on and off.
Oh, I know this.
I also did. I think the other day- I definitely-
Well-
Imagine.
Yes.
Yeah. There are quite a few.
Say it's a very.
Yeah, oh, yeah. And she can read music.
I see the court reporter is with us. For the record, the commission voted to come back into open session to consider the matter involving the separation of Mr. Young. Is there a motion in that regard?
I have a motion regarding cause. I move that based upon the preponderance of the evidence that the department's decision to separate the individual was reasonable.
Second.
It's been moved and seconded to affirm the department's decision that the separation was reasonable. I'll poll the commissioners. Commissioner Miller,
Yes.
Commissioner Smith,
Yes,
Commissioner Clary,
Yes.
and the chair also votes yes. So the separation stands as issued. Is there any other comment that,
Yes, I just we want to make sure that you know, Mr. Young, that because this was not that disciplinary, you have the right to request reinstatement from the city without any wait time. So you can request reinstatement to ITMS, is that?
ITMD.
ITMD, or any other open job at the city that you believe you have the qualifications for.
Well, I was told that, and here's the problem with this. Since my separation, this CJIS rule has been placed on positions that I can go to that supported my salary. So I'm kind of not at the position to where, and my position at ITMD was an associate when I first started out. So
Well, I'm just saying that any department that has someone with your qualifications doesn't have to be ITMD. You are welcome to apply for reinstatement to that job.
I think the point that she's making is that normally if this was disciplinary, you would have to wait a minimum of a year.
understandable.
that does not apply in this situation?
I understand your comment about it wouldn't give you the same remuneration, you might not the same support for your family. I get that, but it would get you back to city benefits and your pension and your health insurance, and it would be income. I don't know what the job would be. It would be a job that is you used to have.
You're
Right.
cutting out, Commissioner Cleary, you're cutting out there.
You're right, and I didn't have the microphone anywhere near me.
I was told that being reinstated, that I only can get reinstated to the last position I had.
Correct. It's only to a title that you've held, but Mr. Donahue or I am happy to talk with you, when you'd like to, about opportunities with the city, reinstatement, any of those things, so that you're apprised of positions that are available. And if there are some which you're qualified, we can make sure that, we're in communication so that you know what they are.
So I'm coming back as just a regular Joe Schmo that never been in the city again. So they get to make the decision if they want to get me, keep me or not, like that.
You would be applying to open and competitive positions, and I can certainly work with you to identify which ones those are. And you can apply for reinstatement to your previously held title in ITMD. I don't know the circumstances of that or what the current requirements are, but what we're saying is that unlike if this were a disciplinary action, it's a separation. So you don't have to wait a year in order to reapply with the city, and you can apply for reinstatement. And I am happy to work with you on that. Mr. Donahue would be happy to work with you on that as a resource.
I got another question. During this trial, I found that there were some things in my record that I was not made aware of. So I'm assuming this is going to follow me, the anonymous comments, the anonymous things that was from email. How does that help or hinder me getting a new job?
That would have no bearing on your ability to get a new job with the city.
So my record would not be disclosed, as far as not my criminal record.
Right.
That
Yes.
stuff that was put
No,
in my
you,
employee file.
it's one employer. So, your employee record, your personnel record, which you always have access to if you'd like to see it, is, disclosable to other departments that want to hire you. But you're applying to open and competitive positions. So you're being taken on your merit, you compete, and you're not precluded from competing because of being separated.
No, I'm saying that stuff in my employee file that cannot be a factor on, say, hey, this guy had this problem here, or they were, because what I'm getting at basically is These are things that's in my file that was not brought to me. There are anonymous people that's not brought to me. And I shouldn't have to bear that and try to compete for a job and have that attached to me when I had no idea that this wasn't even in my file.
I'm just gonna jump in. I think these are all great questions. They should be directed offline to
Agreed.
DER. So
Yeah.
I would recommend that you follow up with DER with all of these questions.
Absolutely.
And I have one, we have the decision.
Well, we get the decision in writing.
Yeah.
Yes.
When's our next scheduled hearing? Or meeting, regular meeting? Is it 2 weeks? Do we have anything in between? Actually, don't know.
I have.
Is this off the
June-
record at this time?
June
This is
3rd is the
termination
next meeting.
Right? We're from, back in November.
December.
But so with it, all due process as far as the city, that's expended at this point, right?
Technically, the commission still has to issue a written summary of its decision, but the formal decision has been made effective as of today. Yeah, we will.
Next meeting is on.
Okay. You know, so we'll file and then we'll figure that out. Are we done?
Well, this item is concluded.
Thank you.
I move that this meeting of May 20 of the City Service Commission, oh, you want to ask if anybody said?
Right, this is the final item on our agenda, so we're done with our regular meeting. What we normally do is I ask my fellow commissioners if they have any information or announcements they wish to share about a future meeting. But it's not going to involve any of the parties that are here.
Okay. Thank you.
Thank you.
And I'm off record as well.
Yes, we're off, effectively, we're off the record
Yes.
because
Okay.
you're just handling the one item.
Right, correct.
Not the-
So
not
I
the
just wanted to
whole
make
meeting.
sure, I wanted to make sure before I left the meeting. So thank you very much. You guys have a good
Thank you.
afternoon.
Thank you.
Thank you very much.
And Gertie.
Well, Mr. Patterson, we thought.
Okay, just in case anybody did want to say anything about something else that's coming up, if anybody's going to be missing meetings or,
Well, I'm not gonna be here to June 17th.
Okay,
meeting, just so everybody
that's all right.
knows.
and apparently our new commissioner will be joining us.
Yes.
So that's the good news. I have nothing else.
It's an excellent choice.
She was a deputy, wasn't she?
All right.
Or was she
She
not?
was a long-standing senior.
Mhm. Just at the top of the letterhead.
Yes.
Was responsible, was an expert on record retention?
That's Pete Block.
No, it was a woman. She came to talk to us at MPS, like 12 years.
Ellen,
Oh, before
Years
Pete.
ago.
It
Was
was
it-
Pete's predecessor.
Ah,
Oh,
Ellen Tengen?
was it?
what's Ellen Tangen? I knew it wasn't my neighbor down the street is,
She was also my go-to tax expert. Now that she's gone, my life is hard. Yeah.
adjourned meeting of the City Board of City Service Commissioners.
Second.
So moved and seconded that we adjourn. I'll poll the commissioners. Commissioner Miller, Commissioner Smith, Commissioner Clary, we're adjourned.